Now, I would like to introduce you to our speaker today. It's Raymond B. Harvey. He has no personal business or financial conflicts of interest to disclose. Mr. Harvey is an attorney in elder law and special needs and estate planning. We appreciate him taking time to speak to us today on legal planning issues concerning Alzheimer's disease. And I give the podium to Mr. Harvey.
Thank you. I appreciate it. I appreciate everybody out that's on the remote sites that are here. I will do my best to be as entertaining as I can on a subject that is fairly dry. And this is not meant to be that specific, but pretty broad, because I want to hit a lot of different areas. I know in the handouts you have copies of the slides. I'll pretty much be going down through the list of those. But essentially is, why we even talk about this is somebody has been diagnosed with Alzheimer's disease, is people who know much better than I do work in the field. The need for care will grow as time goes on, and certainly unless something takes their life, they will need facility care and some sort of long-term care. So what we're going to talk about is things that people are concerned about, and long-term care certainly deals with people who are disabled, some sort of prolonged illness. It's either at home or adult daycare or nursing facilities, so a variety of places wherever somebody is. But the things that they worry about the most is what I plan on talking about. How it's paid for. Probably the number one concern. A close second to that are decisions, financial and healthcare decisions that people have to make. Those are the two biggest things, and the things that certainly I deal with the most in my practice by and large. So we're going to hit on decision making first, get into things that are considered powers of attorney and guardianship. And it really is what if you become incapacitated? And it really is for anybody. We're all just kind of a car wreck away from meeting someone else to make some sort of decisions for us. And I get asked a lot why this is even necessary to do, and why set up any kind of thing. But our law allows things to be done where it's either voluntary or involuntary. Voluntary is I can decide what I want. I can decide who's going to make decisions for me and delegate that authority, decision-making rights to somebody else. And if I don't do that, and I, for whatever reason, become incapacitated, then Arkansas law allows for someone else who can come in and be given that right, which is involuntary in that sense, is I'm not choosing that individual in order to do that. So I'm going to hit on both of those topic areas to some degree. And voluntary really deals with, you can think of these are documents. It's all paper. Some form of advance directive, powers of attorney, they're all kind of generic terms, but powers of attorney, durable powers of attorney, and what the difference is, health care powers of attorney, and living wills, these are the main areas. And you'll notice it really hits on financial and health care. Those are really the big two, and to try to distinguish what these are between the various types of documents. A regular power of attorney is, and all of these are paper, and a regular power of attorney, it's a legal document. Has to be in writing, signed. A person has to have capacity when they sign it. Arkansas, they have to be at least 18 years old, and what that power does is designate someone else to act for you, and it can be as broad or narrow as you want it to be. Regular powers of attorney, though, and all powers of attorney, but regular powers of attorney, they end automatically. All powers of attorney end when the person dies, and a regular power of attorney that's not durable stops if the person becomes incapacitated. This is not what you want. You do not want to have just a regular power of attorney. And I see those on occasion. People will bring them in, but it's fortunately getting rare and rare. It really isn't what you need. You need something that's durable. And the big difference between this and the other power of attorney, setting it up is the same thing. You have to have capacity, you have to know what you're doing, you have to be 18 years of age and be able to designate someone, and there's a formality on whether it has to be notarized or witnessed. But the durable part is going to be stated on the document. Somewhere in there it's going to say, if I become incapacitated, I want this to continue on, and the person that I designate as my agent will have that continuing authority. Now, I will say Arkansas has its own Durable Power of Attorney Act that was initiated a couple of years ago, and there's a standardized form, and it really helped clear up a lot of things, some confusion before, and what brings with that, because the statute stands behind it. And in that sense, anyone who uses that statutory form, it's automatically durable unless you say otherwise. So it doesn't have to have those magic words to it. Older ones, prior to when the act was passed, probably need to still have those in there. Healthcare. Essentially with regular powers of attorney, mostly they're going to deal with financial. Healthcare, by and large, is going to deal with healthcare decisions. And again, the formalities for setting these up are almost identical. The power to make healthcare decisions, essentially someone else is being designated. Now, I get asked a lot, do you need to have two different sets of documents? You don't. You can have a durable power of attorney that has healthcare wording in it. That's perfectly fine. But it's important to have both of those. A lot of times people do financial and they don't do healthcare, or they do healthcare and they don't do financial, and you really need to have both. And people will ask, well, what about my wife? Can they not do whatever, my husband do whatever I need as far as financial goes? And they can't. You assume because you're married that your wife can do anything, or if your child's on your bank account that they can do anything, but they really can't. And the problems that they get into really deal with talking to insurance companies and being able to access retirement accounts is a real big one. Real estate, being able to sell real estate, transfer title. You can't do that if there's multiple owners. So there's real good reasons in order to do that. And my experience is that financial institutions, money people dealing with that end of it are a lot stricter than healthcare providers. Healthcare providers, if it just hints that it covers healthcare, they want to try to work with you. Financial people are just the opposite, so that's pretty common in order to do that. The other, living will. And they're real common. Certainly, if you ever go into a healthcare facility, a hospital, they're going to present you with one, or certainly ask if you want to do those. Living will is to distinguish it from a healthcare power of attorney. Living will is really narrowly focused. It's an end of life, death with dignity type document where you're stating this is the kind of care I want under certain circumstances. But for a living will to even be effective at all, the person has to be, number one, incapacitated, and they're either dying or they're permanently unconscious. If you have capacity and you're still dying, living will doesn't mean anything. If you lack capacity but you're not dying, living will still doesn't mean anything. So again, it's a very narrow set, and a lot of people assume that a living will and a healthcare power of attorney really covers the same thing, and it just doesn't. Not that people don't accept them that way, but by and large, it isn't, not intended to be like that. One point I wanted to make about healthcare decisions is Arkansas passed the Arkansas Healthcare Decisions Act last year. And just to hit on a couple of high points with that, it kind of starts with the premise that any competent adult can give directions about how their health care is going to be, and it still be valid at the point that they lose capacity. And that's what you really want. But the act, the intent of the act is to give what alternatives, and it goes down through a laundry list of people who actually can make decisions. Certainly as long as I have capacity, I can make healthcare decisions for myself. I can name an agent through a healthcare power of attorney to do that, or a court can do a guardian, and I'll talk about guardianships here in a second. And the guardian has that legal authority to make those kinds of decisions. Or under the Act, there can be a surrogate, and the surrogate actually steps in and assumes the authority to make health care decisions. So that's really new, real recent, and that's absent a power of attorney or a guardian, that the surrogate can step in, and then only after other people. And there's a priority on who can assume that from the spouse, and if there's not a spouse, an adult child or a parent or the siblings of the adult that go in with that. Very significant. There's actually, standardized forms, which is good, that the health department has come up with that were attached to the original Act. So it's something to be aware of, mainly because it's so relatively new. It'd be a good idea to look at some of that, especially the forms, so you're more familiar with what those are and what those say. Which brings us into, what if you don't have one? And it deals with guardianship. Guardianship is going to court. It's the involuntary way. It means that the person lacks capacity. And they don't have a power of attorney, or they don't have a valid power of attorney. Sometimes people can have a document in place and it still not be valid for all kinds of reasons. They can essentially revoke whoever, power of attorney can be revoked at any time, and if the person wants to revoke somebody else's authority and they haven't been declared incapacitated in the process, then you're still stuck with a power of attorney that just doesn't do anything because no one's going to recognize it. So it deals with guardianship. And guardianship really is, it's a legal process. Again, there's a procedure that has to be followed. You go to court and you stand in front of a judge. And the process to get to that is, someone comes in and they say, okay, mom has advanced Alzheimer's. She doesn't have a power of attorney. We need to establish a guardianship. In order to do that, then we file court papers called a petition. Attached to the petition has to be medical evidence, certain information that I need from a physician who can say, this is my professional opinion, the individual needs a guardian and why they need a guardian. That has to be submitted, presented to a judge, and then we have to appear in court. So the two things that have to happen when you're in front of a judge, we have to show, number one, that the individual needs a guardian. But we have the medical evidence, and generally we have family members that say, here's mom's situation, and yeah, she took a pistol out and she chased the neighbor's dog down the street firing at it, and so we think it might be a good idea if she has a guardian appointed. Something like that where it's obvious. You don't go in, people do eccentric things all the time, and people do things that are not in their best interest, and that doesn't mean a judge is going to appoint a guardian over them. If that were the case, everybody that speeds down the highway would have a guardian. So it's the judge has to decide, number one, the person, if they need a guardian because of their circumstances and that there's sufficient evidence to show that they need it. And the other is whether the person to be appointed as the guardian themselves is qualified to do that. And so essentially in Arkansas, you have to be over 18 and you have to not be a convicted or unpardoned felon. So, and yes, I learned to ask that question in front of the judge. You always want to know if your client is a felon or not. Because in Arkansas law, you cannot be appointed as guardian if you are. So, and in guardianship really comes into person and the estate, and just kind of clarify the difference between the two, because you can have both or you can have either, and sometimes there's reasons just to have one and not the other. Guardian of the person, it's just like you think. They're going to be able to make personal decisions, healthcare decisions, where they're going to live, what type of medical care they're going to be able to have. And in a guardian of the estate is over their assets. Taking care of their property, their income, their Social Security that's coming in, and making decisions about both of those. if you're appointed, if you do guardianship and you're appointed as a guardian over somebody's property, the judge is going to require you to post bond. It's a requirement of being appointed a guardian. It's to ensure that if someone absconds with somebody else's money, that there's some kind of guarantee that it's going to be protected in with that. But forever on after that, and one of the distinctions to keep in mind between a power of attorney and a guardianship is, a guardianship is forever, there's oversight by the judge from that point forward. If you're appointed guardian over someone's money or over their person, you have to report to the court that person's status at least annually. And you have to, under certain circumstances, get the judge's permission to do certain things. For example, you're guardian over your mom and your mom has a house, you need to sell the house, you have to go to the judge and get permission to sell the house. You can't just go out and do anything you want to as a guardian. There are limitations on what a person can do. So it's all intended under guardianship. The whole idea is whoever needs a guardian appointed needs the court's protection to make sure that that's necessary, number one, and that they're protected within the system to the degree that the system can protect them. So, which leads us up to how are you going to pay for it? Probably the single biggest thing, and the thing that becomes more critical. And there's different things. Paying for care really comes down to certain things. Medicare, what Medicare does and doesn't do. Medicare, if you break a hip and you need to go into a facility for rehab, Medicare does a great job. If you need long-term care, Medicare does no job at all. Extraordinarily limited, 100 days maximum. Medicare only pays fully for the first 20 days. There's a copay to the rehab or skill facility after that, up to 100 days, and at that point it stops. One thing about that I wanted to point out, there is, for those of you that deal with this, there's a case, a lawsuit, that actually forced the federal government to make changes under Medicare for years, and still common belief today that if someone does not improve when they're going through skill care, rehabilitative care, under those 100 days, that Medicare stops. And I still have people who call my office 2 weeks ago. Essentially with that problem is dad's going to be discharged, and the notice is pretty short, you only get a couple of days. Dad's going to be discharged from the facility in a couple of days. He still needs care, or he hasn't received this full 100 days. There is they call it the improvement standard, but that's just not the case anymore. They cannot kick somebody out. They cannot stop care under that 100 days because somebody is not improving at all. It's just not. It took the case settled over a year ago. It took Medicare probably another 9 months or 10 months to get something written into their manuals, and it still doesn't seem to have filtered down to the local people. So, something to know. I don't have a slide on that, but it's something I wanted to bring up in dealing with that. So that kind of leads us to the big daddy on how to pay for long-term care. Really we're talking about in-home care or nursing facility care. You got three choices. You got what you own, how much income you have, your assets, and what you can afford to pay. If you're lucky enough to have long-term care insurance, that's a plus, or Medicaid. That's it. There is no other choice. That's where it is. A lot of people end up with Medicaid just because of the sheer cost of long-term care. Nursing home care in Arkansas, probably with facility care and prescription drug care, prescription drugs on top of that, easily $5,500 up. And some of that depends on where it is in the state. Some places are a little bit less than that. Some places are a little bit more. But when you're looking at an excess of $60,000, $65,000 a year, expense for medical care, it's a lot of money. It's a lot of money for anybody. So Medicaid becomes an option because they run out of money. You know, it doesn't take long at that amount before somebody's accounts are drained down. So basically Medicaid's assistance program, and again, as I said, there's two programs in with that. You know, it was essentially established for a safety net for poor people, but it is essentially the long-term care insurance for the middle class. Basic rules of eligibility, and I'll talk about those, deal with income and assets. I will say, because I deal with Medicaid quite a bit, don't expect Medicaid to make any sense whatsoever. Don't expect there to be any kind of logic to it. There's none. There's no A to B to C, and you can't go, oh yeah, well that makes sense now, because there's going to be stuff you'll just shake your head and say that makes absolutely no sense. It defies logic. That's Medicaid. It does not play well with anybody else, which means that it will be counterintuitive if you deal with estate taxes or whether or not somebody can make gifts. Any other area of the rest of the real world, it does not play well with them. Medicaid's its own little universe, it's got its own set of rules, and it plays by those rules. But eligibility kind of deal with principally, number one, does the person need the care, medically needing, in order to need long-term care. Because if they don't need the care, it doesn't really matter whether everything else falls in place or not. I will say that I've dealt with that issue twice in my career. So the last 17, 18 years, I've had that come up twice where the real issue was whether they needed the care because they needed it for a medically necessary reason. The other category is age, blind, or disabled. So 65 or above, so who'd have thought you hit 65, you're automatically determined to be disabled under the Medicaid program. Blind, disabled, disability generally is determined by, you know, if anybody says Social Security disability or SSI, makes a determination of whether somebody's disabled or not, and that really falls under that definition. But the things that come up the most, the things I get asked about the most, and the sheer issue with getting Medicaid benefits come back to how much income somebody's got and how much assets they have. So, income. This is one of those things that I said doesn't make sense. Arkansas, and for whatever reason, the decision was made, and was made many, many years ago, decided, and I will back up a second, Medicaid, it's a federal program, federal guidelines, federal statute that they give to every state to run. And so there's no, every state can tinker with it, and every state does do that, Arkansas included. And one of those ways that they do is this area. So income gets capped off, and in Arkansas, it's if income eligibility is capped at right now $2,163. That number changes every January 1st. It's based on 3 times the SSI rate. So when SSI goes up, that number goes up as well, which essentially means it's a carved in stone line. If you make above that gross amount above that, technically you don't qualify for Medicaid at all. It doesn't matter how bad you need the care. It doesn't matter whether you have assets or no assets. If your income's too high, you're not going to qualify. And in looking at that, they only look at the applicant's income. They don't, with a married couple, they're not going to look at both. They just look at the person's who's making the application and applying for it, whether or not they exceed that. Not everybody does, but it does happen, especially if somebody receives Social Security and a pension. Most of the time they're going to pop over that number. So fortunately, the federal government says, we'll give you a way to get around that, but you've got to jump through the hoops in order to do it. Basically, what that means is you have to set up, and it goes by a couple of different names. It's either called a Miller Trust or an income trust, or income-only trust, either way. It is a trust document. And Department of Human Services gives out that document. Not with a lot of explanation about how to deal with it, but they will give you the document. And it's kind of a fill in the blank. And so if you deal with this issue ever, and someone needs to set up one of these trusts, use that form. I can do you one that looks great, but it's not their form. And their form, they're looking for their form. All of its misspellings and all of its odd words, don't retype it, don't do spell check, don't correct it, just Xerox it off, liquid paper which says fill in the name, and just write it in. They understand that, and it goes through their system. So that's one part of it. The other part is, it is what it is. It is a new checking account. That's all it is. You have to have a new checking account because the money has to flow not to the person who's applying, but to the trust itself. That's how they get around the stipulation of having too much income, is basically this trust deviates the income stream, so it goes through a new checking account. And out of that checking account, there's certain areas where the money goes. The person keeps $40 a month. If they're paying for other health care, such as a Medicare supplement policy, that can be paid out of it. If there's a spouse and the spouse is to get income from them, and I'll talk about that in a little bit, then that comes out of it. And then the rest is the person's contribution to facility care. If they're at home and they're receiving benefits under Elder Choices, and generally both of those, facility care Medicaid and in-home care Medicaid are almost identical. This is one difference between the two. There is no contribution, so the money in the trust is used slightly differently than what it is here. So not as difficult to deal with, but it still has to flow through that income account, and basically goes in and comes back out. And every month it's like that. It's not real. It sounds more complicated than what I think it really is. Once the account gets set up and once you go through it 1 or 2 months, it's really not any big deal. But just big thing to remember about that, it is only income. It's not the other spouse's income. No assets can go in there, and it's very strict about how it comes back out. And as long as you go by the rules, then you're not going to have a problem with that. The big thing is just remember that if it needs to be set up, that's the last thing you do before you go submit the Medicaid application is drive past the bank, go in the bank, set up the account, get the account set up, then go to Medicaid and submit the form. So, and that's income. And I'll talk about spouse's income here in a little bit, but the other thing is other types of assets. Because to get Medicaid, you can only have a limited amount of assets. If for an individual, if I go to apply, I can only have $2,000. And if my wife and I both apply at the same time, together we can only have $3,000. I don't know why we both can't have 2 each, but the month after we qualify, I can have 2 and she can have 2. Again, it doesn't make sense, and there's no explanation of that illogic. But you still have to get down to $2,000 for an individual person of stuff that they consider countable or available assets. Some stuff is and some stuff isn't. And you start with the basic premise that it's all countable unless they say it's not. And it's just figuring out what they say is not. So, countable. It's kind of what you think it's going to be. Real estate, you always look at that. Non-home real estate in particular. Cash, checking, savings accounts, certificates of deposits, promissory notes and mortgages. Not the kind that you're paying on, but the kind you hold for someone else. Sometimes people choose to sell, particularly real estate, and they carry it themselves. So, for example, I'm selling a piece of real estate for a lot that I own, and I'm carrying the mortgage, and they're paying me on the mortgage until they get paid off. That's still an asset of the unpaid part for them to buy off that piece of property is still an asset. It's still going to count. Stocks, mutual funds, bonds, trust accounts are all looked at. Retirement accounts are looked at. IRAs are looked at. Cash value and life insurance policies is another one. Mineral rights, and there's various ways that those are looked at, whether it's paying out or not paying out. About anything you can imagine, if you own it, it needs to be looked at. Now, it may not count even if you own it, but again, you have to figure out what's not going to be included toward that $2,000. And some things are kind of excluded. So the home. The home's excluded, and the home's an oddity as far as assets go. It's excluded, generally excluded, but excluded under certain specific. If I'm single and I make an application and I own a home, being a single person, I have to have the intent to return to my home for it to be excluded. If I don't have the intent to return, it's not going to be excluded as an asset. Now, that intent can be any kind of intent. My agent can say he's going to go back. And it doesn't have to be a reasonable. People can't say, well, excuse me, he is comatose in a nursing facility, and clearly he's not going to be going back home. It does not have to be a reasonable intent, just as long as the intent is expressed in doing that. Now, being married, if I have a spouse that lived there, it's going to be excluded automatically just because they live there. I don't have to have an intent to return because there's a spouse or dependent child that lives there, then it's going to be excluded. Vehicles, one vehicle gets excluded. It's pretty much regardless of value. There's if it's a single person, there's a dollar limitation, but by and large, that's not a major issue. If the vehicle is used to transport the person for medical care, then it's not going to be counted regardless of value. But it's only one. So the second vehicle, the third vehicle, the fourth vehicle, you got the four-wheeler, the motorcycle, the RV, the boat, the trailer, all that stuff's going to start counting. It's just one car. The most expensive one is what's going to count. Life insurance, cash value up to $1,500, that's excluded. Burial spaces are excluded, which I really appreciate because at least I know that I can get buried without being the dependent. Burial funds. The big thing about burial funds is you can have $1,500 or you can have a prepaid burial arrangement. You can't have both, although it doesn't say that. Although I don't know where you can get buried for $1,500. Have no clue. I guess if you own the land and you have a backhoe and you can get away with it, you can do that. But that's just amazing to me. $1,500. Yeah, okay. You can't buy it. That's just having a rock with your name painted on it because you can't buy a headstone. But prepaid burial, you can do that. And the thing about prearranged burial, basically you go in and you pay for all what they're going to do, and you pick out the casket and arrangements and whatever you're going to do, and you prepay that, whatever that is. And for Medicaid purposes, which is not listed anywhere that I can find, it has to be an irrevocable burial agreement. I don't know anybody that ever revoked one. Yes?
What about prepaid crematory arrangements? Is that the same?
Yeah, and I'm sorry, the question was about prepaid crematory. Yes, it is.
Okay.
It'd still be the same
Because
thing.
that's already paid and done, a done deal.
Right. But it's the irrevocability part, which is not a big deal. But if you don't have something from the people that you're buying this from that says it's irrevocable, it's going to be counted. Major irritation if you don't know that. Essentially because the process takes so long. you file an application for Medicaid, it's a paper process. You got to show all this stuff. You got to show the home, you got to show if you own it, you got to show the automobiles, and you have more than one, is you got to produce something that shows the value of the other vehicles that you have. Burial spaces, you got to come up with something that shows that you own that, and that can be a challenge. Life insurance, you got to get something from the life insurance company that actually shows what the cash value in the policy is, or what kind of policy. Some policies have no cash value at all, but you got to produce all that stuff. So once you submit it all, it usually takes months before you get any kind of straight answer back for all kinds of reasons, and so it's not unusual for go 2, 3, 4 months. What you don't want is to go 2, 3, 4 months and then come back and say, oh, by the way, everything's fine except for your burial was not irrevocable. Well, that's all well and good, but then you go 2 or 3, 4 months and they say, well, you weren't eligible during that 2 or 3, 4 months. And if you get it made irrevocable now, you'll be qualified, but not prior to that. Well, all of a sudden you've got this enormous bill that's hanging out there because you haven't been able to pay it all this period of time because you only had $2,000 when you filed the application. So when they take 2 or 3 months to actually say, no, you weren't, you've got a 2 or 3 month nursing home bill. Fun and games. So income, assets. The third one, did you give anything away? That's always the big, and I get asked a lot of stuff about this. And gifts is not an eligibility criteria, but it can be a serious impediment to receiving benefits by somebody who's done that. I get asked a lot. We get calls all the time. I want to put my house in my kids' names, or for all kinds of reasons. They're scared that the government's going to. Everybody thinks the government's going to come take their property away. And so they get concerned about doing that. So they want to transfer stuff. And honestly, when somebody calls and they want to do that, that's automatic. They have to talk with me. I mean, they have to sit down and talk with me. We just won't do that because I have to make sure they understand you are giving property away and you may be causing problems. That comes under this heading. So when you file an application for Medicaid benefits, one of the parts of the application is a sheet of paper that says, have you given anything away within essentially 60 months prior to the date that you filed the application? And you're going to list out whether you did or whether you didn't on what that was. And they're going to want to know what the value was. And people do all kinds of normal stuff all the time that's just not illegal. They pay for kids' college education, they give them cars, they loan them money, they pay off kids' debts, they give to any kind of charity that they choose to. All kinds of things people do in the real world, which are just perfectly fine. You can do anything you want to do with what you own. There's nothing illegal. You can give it all away to anybody you choose to. Now, that may not be a wise thing to do, but you sure can do it. The thing about this is Medicaid, it's a problem if you give property away. And that's for less than fair market value. So if you want to deed your house to your kid for $10, and your house is worth $100, it's a small house, but if it's worth more than what you get for it, the difference is going to be a gift. So you just can't do that and expect that to happen. Now, if it's more than 5 years ago, it doesn't matter. Legally, they can't ask about that, nor can they penalize you if they know about it. It just doesn't make any difference. But basically, the penalty is no Medicaid benefits for a period of time. So you get this delay because property was given away, and it's going to delay. Good rule of thumb right now is it's going to be about a month for every $5,000. Today, it's 1 month for every $4,955. A lot of Medicaid numbers and things are very date specific. This one in particular changes every April Fool's Day, which I think somebody had to be really having a good day when they thought that was appropriate time to do it. But that's when that number comes up. So, you might want to look at it in this sense that a lot of stuff is on a timeline, and based on the day that you file an application, looking back 60 months is going to determine were there gifts. And, in a sense, five years is a long period of time. And I can't tell you what I did 5 months ago, much less 5 years ago. And if you want to ask me a specific question about why did you write a check for this person, 4 years and 11 months, I may not have a clue what you're talking about. So it's extraordinarily difficult sometimes to figure this out. There are people who deal with cash. My dad dealt with cash all the time, and it was a generational thing with him because that's how he grew up. That's what he was comfortable doing. So you're not going to have a paper trail. You're not going to have canceled checks. You're not going to have credit card statements to backtrack on. If you're the kid coming in looking at mom or dad's stuff and trying to figure this out, or if you're the spouse who didn't do all the bills and your husband or wife did, and they're the ones that has advanced Alzheimer's, it's going to be difficult. But they look back to 60 months and try to figure out, you got before you file the application, you really got to figure out, well, what have I given away? And you add all that stuff up over that period of time. So if you paid off a kid's debt, and that's $5,000 there, and you gave a grandchild a car, and that's another $2,000 there, that's $7,000, and Medicaid's going to look at that amount, and based on the divisor, the $4,955, is going to tell them how far in the future they're not going to pay anything. And how it's going to get delayed. So again, the delay is basically 1 month for every $5,000 from the day that you filed the application. So the gift could have been 3 years ago and could have been for $5,000, but there's going to be a month's delay from the day you file the application. They are not going to pay anything. Now you have to keep in mind, when the person gets to that point and they have that penalty and that delay of Medicaid, they have less than $2,000 in assets to cover that period of time that Medicaid's not going to pay. So yeah, it's an extremely difficult situation for most people to be in, and sometimes for just real innocent reasons. Again, as I said, people can do a lot of things that, in the real world doesn't matter. It is perfectly okay. You get into Medicaid world, you get into this, and you get into that kind of problem. In saying that there are delays, then you get into there are exceptions to the transfer. I didn't list them all here, but basically spouses can get property back and forth. It doesn't matter. It's still going to count, but there's not going to be a penalty if I apply and I give everything to my wife. It doesn't matter. It's still going to count toward the assets anyway. It really won't make any difference. But if I have a disabled child, I can transfer property, I can transfer house, I can do anything I want to for the benefit of that disabled child, and there's exceptions to an exception to that. The other thing I wanted to get into is if it's all well and good if it's a single person, it's pretty straightforward, but when there's a spouse, it's a whole different deal. The law, and they're called the quote spousal impoverishment provisions, really are there to protect the spouse at home, the one that's not sick. The one's in the nursing home or receiving facility care is one thing, but the one that's not sick is the other. And what the law is supposed to do, it does a couple of things. It helps to protect a minimum amount of the assets that the couple has. And the other is if the spouse at home has very low income, is to help supplement that income if there's additional income in order to do that. And really what that means is, asset-wise, they go in and I call it a snapshot, but they have to determine, I go in and make an application for Medicaid, and they look at my assets and my wife's assets to determine am I asset eligible or not. And so they take all the countable stuff and add it all up. In my little example here, if you did that and you had $160,000 in countable, my wife's protected amount is going to be half of that, $80,000. And my $80,000, my half, has to be spent down to $2,000. So in essence of 160,000, we're going to have 78,000 too much. And then you have to do with whatever that too much is, which really is not the purpose of this discussion. I'm not going to really get into that, but that's essentially the problem, is to get it down to a certain amount. But the snapshot is determined based on, depending on which of the two programs that you're trying to apply for. Facility care, the date of the snap, because you got to determine if it's going to be half of what, and the half of the what is determined on the day that you start receiving facility care. So, and that includes hospitalization. So if the person has, they have a massive stroke and they go in the hospital, and from the hospital they go to rehab, and rehab they go to a nursing facility, it's going to be the day that they hit the hospital. That's when that snapshot is. So it's whatever was in the bank accounts on that day, the CDs, the cash value, all whatever added up to that day, that's the baseline number, and it's going to be half of that. Now, and if it's in-home care under elder choices, it's going to be the snapshot date's the date the application actually goes in. So unless they're extraordinarily poor when they submit it, they're really not going to be asset eligible when it's actually, or a lot of times not going to be asset eligible when that application is filed. But it's not always half. There's upper and lower limits to it. So if this was, instead of being 160,000, it was 500,000 when they went in. It's not half of the 500. There's a maximum amount that the spouse gets to keep. That changes every January. The maximum right now is $117,240. So everything else, whatever you subtract $117,240 from $500,000, that's what the spend down is going to be, whatever that amount is. So it's going to vary. There's actually a lower level amount too. Somebody comes in and the lower amount is $23,448, which means if they only have 20,000 total countable assets, there is no spend down. They're there already. They're already below the minimum amount, and the spouse at home gets everything at that point. The other part of that is income protection for the spouse. Again, the well spouse. Eligibility-wise, for the one in the nursing facility, they're not looking at their spouse's income, but once they're qualified, they do go back and look at it. So if I submit an application and I become qualified, they'll come back and look at my wife's income and compare it to whatever there's this long archaic calculation that they do. But basically, they're comparing it to this baseline amount, which right now is $1,939, and that will increase July 1st. So there's, again, different dates for different things. So if my wife only had $939 total gross income, she would be able to keep $1,000 of mine would come back to her, assuming that I had $1,000 of income to begin with, and then the rest of it would be toward my care and a contribution. That $1,939 can go up. For example, somebody has mortgage, rent, other shelter expenses that they're going to need, then it can go up from that, but it maxes out at $2,931. Last but not least, estate recovery. Will they come seize your stuff? Well, yes and no. If anybody who receives Medicaid benefits, not under every Medicaid program, but certainly under these two programs, if you receive Medicaid and you've been in a nursing home or elder choices and you die and you owned anything that has to go through a probate process, they will put a lien against it. They don't come seize it, they just tie it up till you have to sell it and give it to them. Now, if you think about it, when this occurs is a really kind of narrow set of circumstances. If the person's married, and really, when you qualify, what do you have? Well, you got nothing. You got $2,000 and maybe a house. well, then that's okay. So really, all you're dealing with is a home. You're not going to have anything else that's hanging out there, in most cases. So if I'm married and I get on Medicaid and I die, and I own a house, typically husbands and wives own it together. Now, not always, but by and large. So in my case, if I did and I died, there is no probate. My wife just owns a house outright, so there is no lien, there is no estate recovery, unless my wife goes into a facility or my wife receives Medicaid, and at her death, if she still owns that house, there will be a lien. The lien doesn't follow from me to her. It only applies to the individual and what Medicaid benefits they received.